Yes, a very good evening to all of you. All set to start the contract tag today? Yes, everyone, welcome to the revision sessions for CA Foundation June 2022 examination. A very warm welcome to each one of you. Good evening, everyone. Good evening. I can see familiar names. Yes, good evening to everyone. Today we are going to start with hi everyone. Good to see all of you. Good to see you all. Good evening Sarthak, Arfan, Hariom. Good evening everyone. Hi Jatin, good evening. I'm fine Arfan, how are you? Feeling confident after yesterday's session? Yes? Okay. Hi Kinneri, good to see you. So today students we are going to start with the Contract Act 1872, your favorite act. Hi Aman, hi Janvi, hi Harsh. Yesterday we discussed the Companies Act and it was a very good session because you all answered so well and we could complete the entire act in 2 hours flat. Today my target is to complete 3 units of Contract Act. Let's see if we can manage to do that. Hi Prince, fully charged up for today's session. So nice to read that. Yes, even I'm very enthusiastic. I am also very, what should I say, eager to start with the Contract Act, and your enthusiasm and your positivity is actually very inspiring. Yesterday's session was superb. Thank you so much, Sonakshi. It's lovely knowing you guys. Although I have not seen you, but it's like, I know you since a long time. You guys have attended all my sessions. So it's like I've been teaching you since a long time. So that connect is always there. Chalo, let's begin with the Contract Act. Yes, today I am thinking of covering the first, second, and let's see if we can do the fifth unit today because these are manageable. Yes, they are manageable. So we should be able to complete the first, second, fourth or fifth. We'll decide. Okay, depending on the time. No, Shri, there is no chance of postponement. Anyways, the exams have postponed because of the CBSE and ICSE exams. I don't think there will be any change in the time, in the schedule this time. Okay, chalo, let's get started, guys. In case you are attending this revision lecture for the first time, if you missed the revision yesterday's lecture, then it is already available on YouTube. You can go and refer the revision lecture 1 later. And in case you wish to download this workbook, I have given a link in the description box of this video. So just click on that link and you will be able to download this workbook. Just take a printout and solve this, attempt this along with me. Okay, so write and practice, that is my motto. So if you write the keywords, you will be able to remember them for the exam. So write and practice. Okay, and after the session is over, I will be sharing these handwritten notes in my doubt solving WhatsApp group as well as the main study group. Okay, students. So the link for both the WhatsApp groups is in the description box. In case it is full, just let me know because very frequently, and very fast these groups get full. So I will share another link with you. You can join that group. Yes, chalo. So let's start with the Contract Act 1872. Now this act came into force on 1st September 1872 and it is applicable to the whole of India. It is also applicable to the state of Jammu and Kashmir. After Article 370, yes, there were many acts which were not applicable to the whole of India. But then Article 370 has now been removed. Writing practice, Raghav, this is writing practice. Yes, this is writing practice. So just take a printout of the workbook and you can write and practice along with me, right? You can write as you watch the lectures. Now, where was I? Yes, the act applies to the whole of India. It applies to Jammu and Kashmir also. Will all this be asked in the exam? I don't think so. Now, definition of agreement. But before that, you should understand that to make a valid contract, the first thing required is a promise. Yes. So let's say, for example, that you have promised to supply goods to your friend. That simple promise will lead to a contract if all the essential elements are present. Now, how will you remember the definition of agreement? How will you remember this? See, I'll show you actions, okay? Every promise and every set of promises forming consideration for each other is an agreement, okay? So in case you wish to remember the definition, using hand movements is an excellent way of remembering definitions. So if you are, ready to do that with me, and don't worry about people looking at you in your house. Just do these movements with me. Every promise and every set of promises forming consideration for each other is an agreement. All right. Chalo. So if there is one promise, it makes an agreement, and if there are many promises, when they come together, it forms an agreement. Now, what is the simple equation of agreement? Agreement is nothing but offer plus acceptance. I'm not asking questions to you because these are very simple concepts. Everybody must be aware of it. When we add the element of enforceability, then this will become a contract. So agreement is offer plus acceptance. Only when I add enforceability, it becomes a contract. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. So when we add this third element, then it becomes a contract. So what is a contract? The definition is very simple. It says that an agreement enforceable by law, it means when there is enforceability, then it becomes a contract. So contract is simply offer plus acceptance plus enforceability. When all these three elements, they come together, it forms a contract. Now, let's start our discussion, okay? Under which agreements there is a presumption that parties intend to create legal relation, there is enforceability. ऐसा presumption कौन से agreements में है? Social, domestic, business, commercial. Yes, tell me. There is a presumption in which of these agreements? Waiting for your answer. Yes, very good, Jatin. Excellent. In case of business or commercial transactions, there is a presumption of creating legal relation. We assume that parties intend to create legal relation. अलग से agreement करने की जरूरत, अलग से वो agreement में बोलने की जरूरत नहीं है. In case of business and commercial, there is an assumption. Okay, I'm writing business and commercial. Chalo, business and commercial, there is a presumption that parties intend to create legal relation. There is enforceability. Assume करके चलते हैं हम. Parties को अलग से discuss करने की जरूरत नहीं है ये. But in case of, yes, very good. In case of No assumption in case of, Kinnari has already given the answer. In case of social or domestic agreements, there is no assumption to create legal relation. Law बोलता है आपस में सुलझा लो. Now, business commercial may be contract for selling of goods, services. How will I understand whether it is a business transaction or not, whether it is commercial or not? See, commercial means when money is involved. Also, if the contract is not performed on time, there is so much fluctuation in the market price that the parties may incur loss. Uska meaning hota hai commercial. Okay. In case of business, commercial transactions, wherein there is a lot of fluctuation, हम बोलते हैं कि भाई तुम contract time पे perform करो, नहीं करोगे तो फिर party को loss हो जाएगा, वो commercial होता है. So in business commercial, we assume that there is intention to create legal relation. But in case of social or domestic, there is no assumption. Social domestic may be between friends. It may be between family. Domestic is between family, husband and wife. Yes. In this case, we assume that parties don't intend to create legal relation. Okay. Husband and wife. Or between family members. Or husband, wife. Here we assume that there is no intention to create legal relation. हम बोलते हैं कि भाई parties तुम आपस में ही सुलझा लो. Imagine if each domestic promise becomes a contract, तो भाई सब जेल में ही बैठे रहेंगे. Like husband promised to buy the wife a new sari on Sunday, and then he said नहीं आज मेरा किधर जाने का मूड नहीं है. कहता वाइफ से चल तू पुलिस स्टेशन चल, मैं तेरे पे केस कर दूंगी, तूने प्रॉमिस किया फुलफिल नहीं किया. There is no assumption. You can add the assumption by entering into a written agreement, by getting it registered, by having it in writing. So you can add enforceability. लेकिन जब तक add नहीं कर देते, we assume that there is no intention to create legal relation. There is a case law over here, students. There is a case law. Yes, Preetam. Very good. You have already mentioned name of the case law. Balfour versus Balfour. Balfour versus Balfour. Yes. Now, all contracts are agreements, but all agreements are not contracts. What does it mean? What does it mean? All contracts are agreement, but not all agreements are contracts. This can be asked as a theory question. So in this case, all contracts are agreements because to make a valid contract, the equation is agreement plus enforceability. But agreements are not contract because there is no enforceability. So if this question is asked in the exam, you will first explain the definition of contract. You will explain the definition of an agreement. Okay. Then you will say the equation is that a contract is agreement plus enforceability. Whereas in case of agreement, there is no enforceability. It is just offer plus acceptance. Then you will explain that in case of business or commercial transactions, there is intention to create legal relation, but in case of social or domestic, there is no such intention. It is just an agreement. And after that, you will also give examples. Okay. So this is how you will frame the entire answer. So if this question is asked in the exam, you will explain the definition, you will explain the equation, you will explain in case of business commercial, there is intention, in case of social domestic, there is no such intention, and you will also give examples. Okay. So this is how you will frame the answer. All right, I don't think I need to explain or discuss all this in detail because you're already aware of the essential elements of a valid contract. The first essential element is that we need to minimum 2 parties. You cannot enter into contract with yourself. You cannot give offer to yourself. We need, what are the keywords over here? Now I will highlight the keywords for you. These words should be present in your answer. two parties, there should be two distinct parties. This distinct word should be there in your answer. See, I know you are aware of the answer to this question, but you should know what are the keywords which the examiner is looking for. So there are two parties. We need two distinct. Distinct means we need two different parties. Distinct also means that the parties must be capable of contracting. Yes, they must be capable of entering into a contract. Yes, Kinnari, this is a question from the compiler, the social and domestic question 1. Yes, agreement has no enforceability because there is no intention. Yes, it is from the compiler. Armina, yes, I will try to do so, but please don't go into that trap. Study and concentrate on how you should study. I have already put up 3 months timetable, 50 days, 1 month. I've done all that, so I will not go to any micro level now. Okay, let's continue. We need proper offer and acceptance. Now, the equation of contract is that there must be agreement plus enforceability. And what is agreement? Agreement is nothing but offer plus acceptance. So can I say that offer is the starting point of contract and this offer must be properly communicated? Yes. Then this is the starting point of contract. There must be proper offer and this offer must be accepted. Acceptance must also be communicated. There must be intention to create legal relation. This is nothing but enforceability. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. And you've already told me that in case of business or commercial transactions, there is intention to create legal relation. But in case of social or domestic, there is no intention to create legal relation. So it's a simple answer. I don't think questions will be asked on this. Now students, please note that in case question is asked, it is basically asked on this. Okay, so you have to memorize the provisions wherein you have to explain enforceability, business, commercial, and most of the case-based questions from essential elements are based on this concept only. Presumption किसमें और किसमें नहीं है. Then we have the consent must be free. It must not be caused by coercion, undue influence, fraud, misrepresentation, mistake. If I want you to explain coercion in 1 or 2 words, what will be your answer? What is the meaning of coercion? In 1 or 2 words, what will you explain? Yes, Kinnari, very good. We can write over here Balfour versus Balfour also. Yes, we can write Balfour versus Balfour. Guys, it's time to answer. It's time to answer. Can you tell me in 1 or 2 words what is the meaning of coercion? Armina, don't feel scared. Just refer my CA Foundation compiler and all the questions I'm telling you will be from that book only. I'll share the link of that compiler with you. 100% questions will be from that book. If you are scared that ma'am मेरा अभी exam खत्म हुआ है CBSE ICSE board का, or maybe you know I'm doing it at the last minute, I'm not confident at all, just refer this book and you will pass. It is my guarantee. Okay, so just refer this compiler and all the questions will be from that only. That's my guarantee. So Armina, I'll share that link with you. You can also connect with me on my mobile number. It is given in the description box of this video as well as on my website. Yes, guys, I'm sharing the link of the compiler. Armina, please go through that. Threatening or committing or threatening, no. LR, I don't think that is the correct answer. I was looking for, in case of coercion, I was looking for these 2 words. There is threat or there is physical force. I was looking for these 2 words because these are the key words which should be present in your answer. These are the key words. See students, I know you are aware कि इसका आंसर क्या होना चाहिए, लेकिन क्या वर्ड्स लिखने चाहिए एग्जाम में, that is more important. Yes, so these are the keywords. How will you explain undue influence in just 2 words? Undue influence, 2 words में, it is nothing but some kind of moral or mental pressure. There is also one more requirement over here. You have to write in your exam that there is some kind of relation between parties. Okay, there is relation between parties, and because of this relation, there is undue influence. So these are the 2 key points that should be present in your answer. Okay, in case of fraud, if I ask you 2 words to describe fraud, what are the key words that should be there in your answer if you are writing about fraud? Yes, domination. Okay, in case of fraud, I'm looking out for words like there is intention to cheat, or there is intention to deceive. I'm looking for these words. If I'm the examiner, I want these cheating and deceiving words in your answer. Okay, in case of misrepresentation, what are the key words that should be present in your answer? In case of misrepresentation, what are the key words? Yes, very good, Jatin. Very nicely written, Jatin. False representation of facts made willfully. Very good. In case of misrepresentation, the words that I'm looking for is there is false representation but made innocently. Okay, there is false representation but it is made innocently without any intention to cheat or deceive the other person. Yes, Armina, you can call me tomorrow. You can call me in the morning. Yes, around 11 o'clock. You can connect with me on call. Okay, if I want you to tell me 2 keywords for mistake, what are the keywords that you will write for mistake? What are the most important words that you should write for mistake? What are the keywords that you should write for mistake? In case of mistake, there is erroneous belief. If I am the examiner, I will want these 2 words in your answer. There is an erroneous belief concerning something. कुछ समझने में गलती हो गई. There is erroneous belief. Yes. Very good, Jatin. Erroneous belief concerning something. Correct. Capacity of parties who are capable of entering into valid contract. Students, please note this section number is important. You have to by heart this section number. I will also in Contract Act highlight the important section numbers जो आपको by heart करके ही जाना है. Okay. Section 11 is important. You have to by heart this. In who are capable of entering into contract. So we have, yes, please answer, students. Only a major person, person of sound mind, and person who is not disqualified from contracting can enter into a valid contract. Okay. So major person, person of sound mind, and person who is not disqualified. Section number 11 is very important. We started the revision batch yesterday. If you have missed the first lecture, it is available on YouTube. Please join my WhatsApp group for doubt solving as well as the study group. I will share the video as well as this PDF in the group after the session is over. You can download the PDF from the e-note section of my website, or the link is given in the description box. Take a printout, be ready before the lecture. The PDF with my notes will be shared in the WhatsApp group. Major, person of sound mind, person should not be disqualified. Yes, Arya, very good. Correct answer. Consideration must be lawful. Section 23. Section 23 is important. It covers lawful object as well as lawful consideration. What is the meaning of consideration? And if you can tell me the Latin phrase, I will clap for you. Yes. What is consideration? What is consideration? What is the Latin phrase for it? Meaning and Latin phrase चाहिए मुझे. Meaning and Latin phrase. Kinnari, absolutely right. Superb answer. The Latin phrase is quid pro quo. And it means something in return. Yes, very good, Kinnari. Very good answer. Way to go. It's something in return. Both the parties should get consideration. There must be consideration for both the parties. No consideration, no contract. अरे क्या बात है यार, क्या बात है. LR, then Preetam, Prince, Ayushi, correct answer. Arfan, very good. Ankita, Bhavani, correct answer. Ramu, Yash, अरे क्या बात है यार, क्या बात है. Very good, guys. Quid pro quo, something in return. There must be consideration for both the parties. Yes. Object must be lawful. What is the meaning of the word object? What is the meaning of the word object? This word should be there in your answer. What is the meaning of the word object? What is object? Object क्या होता है? Let's see if you can answer. Yes, Kinnari, very good. Object means the purpose for which you're today. Kinnari is on a roll. आज तो बहुत बढ़िया आंसर कर रही है. Purpose for entering into the contract. This purpose must be lawful. Lawful purpose होना चाहिए. Yes, purpose must be lawful. The object must be lawful. अच्छा, agreement must not expressly be declared void. What is the meaning of void? What is the meaning of void? बोलो, what is void? No consideration, no contract. Yes. Guys, question will not be asked on all these parts. There are more important parts. तो just warm up कर रहे हैं हम. Yes, the agreement must not be void. What is the meaning of void? Void का meaning होता है it is not enforceable by law. Okay, void means it is not enforceable by law. Now, void may be either, okay, void may be either void ab initio or it may be just void. Okay, it may be just void. Void ab initio means it is void right from the beginning. Let's say that I am entering into contract with minor. Okay, I am entering into contract with minor. Or X tells Y, give me 1 lakh rupees and I will bring a star from the sky. This is void right from the beginning. It's an impossible agreement. And just void means, students, see how I'm writing. Just void means it was valid when entered. Write this somewhere. But later, okay, later it became void due to certain circumstances. So let's say, for example, that A promised to marry B. When A promised, that time it was a valid contract. But later on, A died. Now, is it possible to perform this contract? No. The contract becomes void. I am using the word contract. It's a void contract because it was valid when entered. That is why it is contract. But later on, due to certain circumstances, it cannot be enforced. That is why it becomes void. Okay? That is why it is void. Meaning must be certain. Okay. Agreement must not expressly be declared void. Like there are certain agreements which law says it is expressly void. You cannot enter into those contracts, like restraint of marriage, restraint of trade, impossible agreements. They are expressly declared void. You cannot enter into such contracts. Meaning must be certain. Section 29. In case a question is asked on this concept, students, please note, in case a question is asked on this concept, यही example पे आएगा जो मैं आपको बता रही हूँ. X is a dealer in different kinds of oil. Okay, he is a dealer in different kinds of oil. He agrees to sell 100 liters of oil to Y at 100 rupees per liter. Is this agreement valid? Yes. If it is valid, okay. If it is not valid, then why it is not valid? You have to justify. Exactly, Ritika, you're already there with the answer. It should be, meaning must be certain. It should be clear. It should not be vague. It should not be confusing. It should be clear, definite, not vague. Correct. Is this contract a valid contract? If the question is asked in the exam, यही example पे आएगा. This is not a valid. It's not valid. The reason is that the kind of oil is not specified. कौन सा oil है वो तो specify किया ही नहीं है ना. It's ambiguous. It's ambiguous. It's not a valid contract because the kind of oil is not specified. Please remember this example for exam. If a question is asked, it will be on this example only. Correct, correct, correct. The contract must be possible. It must be legally as well as physically capable of being performed. Okay, it must be physically, legally capable of being performed. So bringing star, moon from the sky, that is not a valid contract. So it must be possible, it must be legally as well as physically possible of performance. Yes, absolutely right everyone. Correct answer. बहुत अच्छा लिखा है सबने. Possibility of performance होना चाहिए. Everybody must be, these contracts, the terms must be such that they are capable of being performed. Okay. Legal formalities like writing, attestation, stamping, etc. If there is a legal formality, then I need to fulfill this legal formality. नहीं है तो अपनी मर्जी से कॉन्ट्रैक्ट बनाओ. Your wish, you can make the contract anytime, anyhow you want. Even oral contracts are valid, students. Even oral contracts are valid. Impossibility, yes, it should not be initially impossible of being performed. Initial नहीं होना चाहिए. ठीक है. Next we have classification of contract. Void I have already discussed with you. Void we have already discussed and absolutely correct answers दिए हैं आपने. Void ab initio हो सकता है or it can be just void. Just void means it was valid when entered. Later it became void due to certain circumstances. Yes, now let me read the comments. Written होना चाहिए, attested होना चाहिए, registered होना चाहिए. Correct. Ramu, correct. Certain contracts must be registered like gift deed. Immovable property को अगर sell करना है, then the contract has to be in writing and it must be registered also. Void contract, yes, LR has given the correct meaning. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Okay, when it ceases to be enforceable. Now, what is the meaning of a voidable contract? Many students get confused in voidable contracts. I'll give you a short diagram. Please draw it if you have a book with you. Now, contract is voidable. Let's say, for example, that the Don forced X to sell his house. There is coercion. Okay, there is coercion. X, the aggrieved party. Okay, the aggrieved party. If you have a book, please write it. Aggrieved party has two options. Either keep quiet, treat the contract as valid, or he realized कि अरे ये मैंने क्या किया, I should have gone to the court, I should have taken action. Or he can cancel the contract. He can rescind the contract. That's a better word for cancellation. He can rescind the contract. Okay. He can rescind the contract. But if the contract is rescinded, he will have to restore the benefit. He will have to restore the benefit. Yes. Now let me read your extra comments. See, students, if you have any extra point, please write it for me. It is voidable at the option of one party. Whether it is to be cancelled or it is to be kept valid, that option is available only and only with the aggrieved party. It is voidable. It is enforceable at the option of just one party, not at the option of the other. Enforceable at the option of one or more parties, but not at the option of the other. Very good. Sarthak, very well written. Contract which is enforceable by law at the option of one party. Very good, LR. Mission CA. Okay, contract which is enforceable. Very good, students. बहुत अच्छा definition लिखा है आपने. Absolutely right. Rescind कर सकते हो, but it should be done within a reasonable time. जो भी benefit मिला है, that must be restored. So suppose X had got, let's say, rupees 5 lakh as benefit. He will cancel the contract, but he will also have to restore the benefit, and cancellation must be within the reasonable time. This option is not available with the person who is causing coercion. Now, When the contract is caused by coercion, undue influence, fraud, misrepresentation, then the contract is voidable. But what if the contract is caused by mistake? Then what will you write, students? What is your answer in that case? What if the contract is by mistake? What is the contract? Yes, LR, very good. I was just waiting for your answers. Very nicely put, Jatin. बहुत अच्छा लिखा है आपने. Aggrieved party has two options. Correct, Kinnari, correct. अरे क्या बात है. People who have written void, pat your back. Correct answer लिखा है. क्या बात है students. Correctly identify कर लिया आप लोगों ने. In case the consent is obtained by mistake, then the contract is void. It is void. Correct. Next, we have illegal contracts. In illegal, the keyword, okay, the keyword is forbidden by law. Keyword is forbidden. In case you find the word forbid in your exam, it is a hint that they are talking about illegal. And also illegal में punishment रहती है. Drug dealing या smuggling or publishing defamatory statement, entering into contract with prostitute, all these are illegal agreements. Okay, so forbidden by law. Forbid is the key word. They are void ab initio. Very good, students. Arfan, very good. Correct answer. Ayushi, forbidden by law. For example, immoral, opposed to public policy. Yes, Ayushi, very good. Forbidden, forbid word should be there in your answer. Valid means all the essential elements are present. All essentials are present. Yes. All essentials are present. Unenforceable contract. What are the key words in unenforceable contract? Yes, tell me, students, what are the key words in unenforceable contract? Unenforceable means unenforceable. What is the key word in unenforceable? The key word is that there is some technical defect. Like it should be in writing, मैंने नहीं करवाया. Attestation चाहिए था, मैंने नहीं करवाया. So for the time being, it is unenforceable. But once this technical defect is removed, okay, once this technical defect is removed, then it becomes enforceable. So there is some technical defect. वैसे ये valid है, all the essential elements are present, but there is some technical defect. Pratham, correct, not enforceable due to some technical defect. Valid in the beginning, but void after some technical defect. No, it is not valid. It is not valid in the beginning, Parsha. You will say that it is valid, but there is some technical defect. It's yes, absence in writing. There is some technical defect. So there is some, because of it is not enforceable. Very good. So oral agreements for sale of immovable property, they should be in writing, na? If it is oral, then the contract is unenforceable. You make it in writing, it will become enforceable. Express contract means it is expressed in words, oral or written. So when words are used, oral or writing, offer, acceptance, both are using words. It's an express contract. But if words are not used, it is understood from the action, conduct of the parties. That is, it is implied by fact. Sometimes it may be implied by law. Parties never intended to enter into contract. Law बोलता है भाई तुम्हारे बीच में contract बन गया है. वेरी गुड स्टूडेंट्स, करेक्ट आंसर. सब इतना बढ़िया रिप्लाई कर रहे हैं ना. And you guys are using the legal words required in the answer, which is very important, students. बहुत important है. Yes. So implied may be implied by fact or it may be implied by law. Implied by fact means that it is inferred, it is understood. The key word over here is inferred. This is the key word. It is inferred from the action, conduct of the parties. Yes, I even got example like bus running on a fixed route. Very good, Jatin. Correct है आपका. Bus running on a fixed route. That's an implied offer. We board, that is implied acceptance. It becomes an implied contract. By law, X by mistake left goods at the house of Y. By mistake. Left goods at the house of Y. Y used the goods. If you have used the goods, you will have to pay for it. It's implied that you're using the goods, you have to pay for it. Arya, yes. It is inferred. The word inferred is important. That is the key word. Inferred. It is inferred. It is understood from the action, conduct of the party, circumstances of the case. You should write circumstances of the case also. Yes. Circumstances of the case. What is the meaning of tacit? What is the meaning of tacit? What does the word tacit mean? What is the meaning of the word tacit? What does the word tacit mean? Yes, it means silence. The word tacit means silence. Students, please note, tacit is not a separate kind of contract. It is a type of implied contract. If in the exam you are given ATM or sale by fall of hammer, okay, if in the exam, yes, very good, Ankita, Jatin, Arya, Ramu, Harsh, very good. Silence, it means silence. If in the exam you are given ATM, sale by fall of hammer, only then you will select it is a tacit contract. It's a tacit contract. Okay. So this is not a separate kind of contract. It is a type of implied contract. Executed contract. Executed means both the parties have fulfilled their promises. Okay, both have fulfilled their promise. Sorry, bilateral में आएगा. Executed, both have fulfilled their promise. Or it can also be unilateral, wherein one party has performed the promise even before formation of contract. Now, X supplied goods to Y. Okay, X supplied goods to Y and Y made the payment. So both have performed their part. It is executed. Even unilateral, it is not a separate kind of contract. It is a type of executed contract. One party has performed his promise. Like say for example, that A's dog was missing. So he gave an advertisement that I will pay 10,000 rupees to whoever finds my missing dog. B found the dog. Now B ने अपना काम तो कर दिया है. B has performed his part. Now only A's part remains. Only his promise is to be fulfilled of paying 10,000 rupees. Since B has already performed his part, only A has to perform. This is known as a unilateral contract. Uni means one. It's a one-sided contract. Whereas bilateral, also known as executory contract, it means that both have to still perform. Both. So here both performed and here both have to still perform the contract. Like X has to still supply goods to Y and Y has to make payment. They both will do it in the future. It is known as executory or bilateral contract. Executory or bilateral contract. Okay, students? So with this, we finished the first part, the basic part of the Contract Act. Now let us quickly proceed to offer and acceptance. Offer is the starting point of contract, so it is defined under section 2 clause A. Very easy to remember, 2 clause A. When one person signifies his consent, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the consent, the assent of the other person, he is said to have made an offer or a proposal. Are very good. Correct answers. Everyone has given correct answers. Very good, students. So what is the meaning of offer? Offer means that the party, what is offer? When one person signifies means communicates. He makes it known to the other person. Communication can be oral, it can be in writing, it can be through action. You are making your proposal known to the other person, your intention to contract known to the other person. You are said to make a proposal. This is very important for case-based question. Mere expression of willingness is not offer. I am only expressing my wish, my desire. It is not an offer. Like say for example, X tells Y, I wish to get married by the end of this year. He is only expressing his wish, his desire. That's not a contract. Has he said, will you marry me? No. A tells B, I wish to sell my car by the end of this year. Has he asked why? Do you want to buy the car? No. Yes, Arya, assent is the key word. It means consent. Yes, correct. In fact, when you write the definition, you have to write it accurately only. But 60-70% is fine. थोड़ा आप own words में लिख सकते हो. It's a mere statement of intention. Yes, LR, very good. It's a mere statement of intention. That's not a contract. You're only expressing your wish, your desire. It's not a contract. Okay, let's go through rules of offer. Yes, rules of offer. Offer must be capable of creating legal relation. Can you tell me what kind of offer will create legal relation? Business, commercial, social, domestic? Tell me. What kind of offer will create legal relation? Yes, offer must be capable of, this is in case of business or commercial. In case of social or domestic, there is no intention to create legal relation. Absolutely correct answer. Hi Ria, how are you? Long time. You didn't attend yesterday's session. Yes, correct. क्या बात है यार, correct answers दे रहे हैं सब. Business and commercial. Okay. Offer must be communicated. Yes, offer must be communicated. अरे सामने वाली पार्टी को ऑफर के बारे में पता चलेगा तभी तो वो एक्सेप्ट करेगा ना. Very interesting case law, लालमन शुक्ला वर्सेस गौरी दत्त. सर्वेंट को भेज दिया था हमने टू सर्च द मिसिंग नेफ्यू, ढूंढ के भी लेकर आ गया. ही क्लेम्ड रिवॉर्ड. रिवॉर्ड मिला क्या उसको? Was he entitled to reward? रिवॉर्ड मिला क्या? He was not entitled to reward because he was not aware of the reward. उसको knowledge ही नहीं थी. When he had accepted the offer, when he went, तो उसको पता ही नहीं था. तो जब पता ही नहीं था तो फिर कैसे accept करोगे? So he was not entitled to reward. Offer must be communicated. Offer must be certain, definite and not vague. Terms must be clear. वो oil वाला example इधर आ जाएगा. Yes, let's see what you guys have written. No knowledge of offer. Okay, he didn't know about the reward. Absolutely right. The offer was not communicated to him. See, students, when you write these sentences in the comment, no, you are actually using sentences which you will remember in the exam. और आप exam में मुझे याद रखोगे, आप मुझे याद करोगे कि मैम हम comment में लिख रहे थे and वही keywords अभी हमको exam में भी काम में आ रहे हैं. No, Ria, it is not necessary. We did Companies Act yesterday, so it is totally different. You watch today's session. Yesterday's session you can watch later. Okay. So students, please participate. Type. ये मत सोचो कि मैम आप कितना पूछते हो questions, कितना type करना पड़ता है हमें. Because you are going to remember all this in the exam. This is writing and practice, or typing and practice, I should say. Yeah. Chalo. Offer must be clear, definite, and not vague. Offer may be conditional. I can put conditions in the offer. Offer may be conditional. But the only requirement is that the conditions must be communicated along with the offer. Okay, they must be communicated along with offer. If I come to know about those conditions later, then I will not be bound by those conditions. Okay. Offer should not contain a term, the non-compliance of which amounts to acceptance. Thank you, LR. Kya baat hai? You are answering also very well. Even I am enjoying with you. You are giving correct answers. थोड़ा पेस अभी पिकअप हुआ है. फास्ट आंसर करो बच्चों. Offer should not contain a term, the non-compliance of which amounts to acceptance. A proposed to B, will you marry me? And if you don't reply by today evening 5 o'clock, I will assume that you have accepted my offer. आप ये नहीं बोल सकते, if you don't reply by today evening 5 o'clock, I will assume that you have accepted my offer. Offerer cannot say that if the offer is not accepted, he will assume, it will be assumed to be accepted. Offer must be communicated. Acceptance must also be communicated. Offerer must communicate special terms or standard form of contracts. If there are certain special terms, conditions, they must be communicated along with the offer. Yes, Ankita, very nicely written. बहुत अच्छा sentence लिखा है. Offer can be made subject to, I like that, subject to any terms and conditions by the offerer. This is what the examiner wants in the exam. It should be communicated along with the offer. Achha, if there are special terms, they must be communicated along with the offer. Standard form of contracts, like say for example, standard form kya hota hai? You go to the bank, your friend goes to the bank, your father goes to the bank, I go to the bank. If we all want to open a bank account, बैंक हमको एक ही फॉर्म देने वाला है, वो स्टैंडर्ड है. सारे टर्म्स एंड कंडीशंस लिखे हैं, लेना तो ले लो वरना निकल जाओ. So it is either accept it or you can't do anything. मतलब take it or leave it. Yes. So in that case, if there are certain standard form of contracts, it is necessary that these terms must be communicated along with the offer. Okay, they must be communicated along with the offer. तो ड्राई क्लीनर के पास हम चले गए. ड्राई क्लीनर ने बिल दे दिया. On the face of it was written terms and conditions apply. It means that they are properly communicated to the other person. अच्छा, मैंने terms and conditions written, I wrote it on the back side, but I did not mention terms and conditions apply, see reverse. Then you cannot say that those terms have been communicated to the other party. Okay, then we cannot say that the terms have been communicated. Yes, Arfan, very nicely written. Acceptance not received in a reasonable time, the offer is not assumed to be communicated. It's not assumed to be accepted. Correct. Very important, guys, for case-based questions. It is important for case-based question. Okay, it is important for case-based question. What is the difference between offer and invitation to offer? Yes, can you tell me what are the keywords for offer? What should I write over here? Who will answer first? Let's see. What are the keywords? What is the examiner looking for? What does he want in your answer? What are the keywords? Chalo. क्या बात है? Harvey versus Facey. Yes, Jatin, correct. Harvey versus Facey. Yes, come on. Tell me the keywords for offer first, okay? Keywords for offer. What will you write in the exam? Yes, Ankita, Harvey versus Facey. Correct answer. Okay, Pratham ne bola hai. I'll write his point first. Pratham says that invitation is only a circulation of offer. Okay, I'll write this. It's only a circulation of offer. It's not a definite offer. Can I write that also? Not definite. Okay, LR is saying offer is final willingness. Correct. Offer is final willingness. Correct. These are the keywords. Harvey versus Facey. Yes, we will write that. So it is only a circulation of offer. It is not definite. What else will you write, guys? What else will you write? Offer is definite. Yes, Priyal. Offer is definite. It can be accepted or rejected immediately. It can be accepted or it. Yes, Pratham, correct. Offer can be converted into a contract. I'll write that also. Can be converted into a contract. Yes, these are the keywords. You just need to convert this into sentence form. Jatin ने क्या लिखा है? Offer is a final expression of willingness by offerer to be bound by the offer which the offer choose to accept it. Yes, correct. काफी लेंदी लिख दिया आपने, but correct लिखा है. Okay, so fine. Offer में हमारे keywords क्या है? What are the key points? It is final expression of willingness. It is definite. It can be accepted or rejected immediately. Yes, Preetham, I will include your point. Okay. I will say that invitation to offer invites offer from other person. It's not an offer. In fact, we are asking the other person to give the offer. Yes, offer can be converted into a contract. Correct, Kinneri. Very good. Acha, can you give me examples of invitation to offer? Ayushi, perfect. क्या beautifully sentence frame किया है. In offer, parties have intention to be bound when the other accepts it. Jatin ने भी same लिखा था. Yes. अच्छा, can you give me an example of invitation to offer? Yes, Steffi. Very good. Offerer intends to be made. Yes, some changes are required. Can you give me invitation to offer के examples? Auction sale. Yes, I will include that. Auction sale is invitation to offer. Display, window display. Correct. I am putting a lot of time in this because it is important for exam. Okay, guys, can you hear me now? Can you hear me? Okay, okay. There was a power failure, but luckily we were able to revive soon. Chalo. Are you with me? Yes. All right. Chalo, let us continue. Yes, continue. Offer may be expressed or implied. ठीक है. Next we have lapse of offer. I'll do that in the end. Abhi nahi. Types of offer. General offer. Yes. General offer. What is the meaning of general offer? What are the key words? I only want key points which you will write in the exam. I want key points. General offer, what are the key words? It is an offer which is made to the public at large. Yes, it is an offer which is made to the public at large. It can be accepted by anyone who has knowledge of the offer. Knowledge is the key word. Okay, so what are the key words? It is made to the public at large. It can be accepted by anyone who has knowledge of the offer. Superb, guys. Public in general, acceptance must have knowledge. Okay. Correct answer. Perfect. Correct answer. It can be, yes. Anyone can accept it. Steffi, but you should also write anyone having knowledge can accept it. Anyone having knowledge. Correct. Then case law, 𝗟𝗲𝗿 versus 𝗟𝗏𝗿𝗀 company. All right. Specific offer. Who can accept a specific offer? Specific offer. Who can accept a specific offer? It can be accepted by the person to whom it is made. It can be accepted only by the person to whom it is made. Yes. Correct. In case of cross offer. Yes, LR. Very good. Correct answer. Naman. Correct answer. Ankita. Pritam. Correct answer. Very good, students. अच्छा जा रहे हो. Maintain the pace. ये जरूरी है. Never give up. Maintain the way you are answering. Yes. Absolutely right, everyone. Superb. Bolton versus Jones. Yes, Ankita. We can write that in the exam. In case of cross offer, there are identical offers. Then it is given in ignorance of the other person's offer. These are the two keywords. Identical offers in ignorance of the other person's offer. Yes, identical offers in ignorance. Both are making the offers without knowing about it. Acha, what is counter offer? Counter offer. I want everyone to participate. Counter offer. This is nothing but bargaining. It is, yes, what are the keywords? It is rejection of the original offer. And this is considered as a new offer altogether. What are the keywords over here? If I was the examiner, I would have wanted you to write modification, variation, qualification. I want these words in your answer. Okay? Modification, qualification, variation. Standing open or continuing offer. Now, the best way to understand this is through an example. Everyone, correct answer. Let me go through your answers. Harshvardhan, Jatin, Ayushi, offer against offer. No, I don't think so. That should be written in the exam. Conditional acceptance. Yes. Rejection of the original offer. Sarthak, correct. Rejection of the original offer. Modification, rejection, variation in the original offer. Correct, Arya. Arya, very good. Yes. Now, standing open or continuing offer. A is a construction company. They want cement bags, so they have invited tenders. X, Y, Z, P, Q, R, इन सब ने टेंडर भर के दिया है. Yeah, but Z का offer सबसे best था, so we have accepted his offer. They said we want cement bags, but for over a period of 2 years. Z बोलता है, don't worry, मेरा तो open offer है, तुमको जब जितने bags चाहिए बता देना. So A Limited placed an order for 100 bags, then for 500 bags, then for 300 bags, 1000 bags. Each order placed will be considered as an acceptance of the open offer of Z. So an offer which is allowed to remain open for a period of time is known as standing open or continuing offer. It is open for a period of time. Yes. Express offer means offer which is made in words, and implied offer, it means implied from the action of the parties, conduct, or circumstances of the case. Absolutely right. Now let us discuss lapse of offer. Who will tell me what is the meaning of the word lapse? What is the meaning of the word lapse? What does the word lapse mean? I want everyone to answer. Students, this is the only way to remembering law. Write and practice. Lapse means to come to an end. Lapse means to come to an end. There are different ways in which the offer may lapse. Please highlight this as important for theory question. This is important for theory question. Offer comes to an end. Offer may come to an end. Khatam ho jana. Yes, Naman. Revocation. You gave the offer, then you revoked it. You called it back. Revocation means to call back. So offer comes to an end. Lapse of time. Lapse of time. A had given an offer to B, and that offer was to be accepted within 7 days. 7 days are over. Offer comes to an end. 7 days are over. Offer comes to an end. Death or insanity of offerer or offeree before acceptance. Acceptance hua hi nahi and they died. Offer comes to an end. It is revocation. It is lapse of offer. Offer comes to an end. By failure to accept the condition precedent, meaning of precedent is before. Now, A gave an offer to B and he said that, will you buy my television set? Give 5,000 rupees advance at the time of acceptance. Now, B gave his acceptance, but he did not give the advance. The condition was not satisfied. Offer lapses. Offer lapses. Guys, keep answering. I am checking your answers. So don't feel that ma'am is not seeing our comments. I am seeing each and every person's comment. I will correct you if you are going wrong. But this is a very good way to write and practice. So please answer in the comment. I am going through all your comments. By counter offer, A gave an offer to B. B gave counter offer. When you give a counter offer, the original offer is rejected and the original offer lapses. It lapses. Yes, Harshvardhan, revocation can be by notice. Revocation by notice. By not accepting in the prescribed mode. X gave the offer and he wanted Y to send the reply by courier only. He said, Y, you should reply by courier only. If Y does not reply by courier, X has the option to cancel the offer. Offer lapses. Yes, Jatin, counter offer does not amount to acceptance. Correct. X gave the offer to Y, mode was specified, it is not accepted in the prescribed mode, offer lapses. By rejection of offer by the offeree, A offered, proposed to marry B, B says no. Offer reject ho gaya, offer lapse ho gaya. By subsequent illegality or destruction of subject matter. Let's discuss an example for illegality. Now, A promised to export onions to B. But before export, government ने ban लगा दिया. Before acceptance, ban लगा दिया. Offer lapse हो गया. Okay, government bans it before acceptance. Offer lapses. destruction of subject matter. X offered to sell a car to Y, but the car is destroyed in floods. Before acceptance, it is destroyed in floods. Subject matter ही नहीं रहा तो फिर acceptance कैसे करेंगे? Offer lapses. Offer lapses. Yes, offer lapses. So students, please mark this as important for theory question. Theory question आ सकता है इसमें. Then we have acceptance. Acceptance is defined under section 2b. When a person to whom the offer is made, proposal made, he signifies his acceptance, he communicates his acceptance. Offer is accepted. Offer is said to have been accepted. So A proposes to sell his house to B. बोलते हैं मेरा फ्लैट खरीदोगे? B बोलता है हाँ खरीदूंगा. वो communicate करता है, he accepts it. वो बोलता है yes, offer is accepted. Yes, offer is accepted. Okay, offer is accepted. Next we have that acceptance must be absolute and unconditional. Students, please highlight this as important for exam. It must be absolute and unconditional. Maximum times question is asked on this. Acceptance must be absolute and unconditional. जैसा ऑफर दिया है वैसे का वैसे ही एक्सेप्ट होना चाहिए, without any variation, without any modification. If we are not accepting it, then this is nothing but a counter offer, and counter offer does not amount to acceptance. Okay, this is a counter offer, and counter offer does not amount to acceptance. It is a new offer altogether. So students, please note that this is extremely important for exam. Section number यहाँ पर इसका याद नहीं रखना है आपको, ये इसका नहीं आएगा. Yes, but this is important for exam because इस पे काफी बार questions आते हैं. Absolute and unconditional होना चाहिए. Okay, it must be absolute and unconditional. Acceptance must be given only by the person to whom the offer is made. Who will tell me the name of the case law in this case? इधर मैं कौन सा केस लॉ लिख सकती हूं? Do you remember name of the case law over here? Acceptance must be given only by the person to whom the offer is made, or it can be given by an authorized person. वो भी ऐड कर सकते हो आप यहां पर, or an authorized person. There is a case law over here. Now why I am asking name of the case law? नहीं हर्ष, लालमैन शुक्ला नहीं आएगा यहां पर. Bolton versus Jones, yes, you can write that name, write that case law. Pratham, yes, we can quote that. Bolton versus Jones. Bolton versus Jones, yes. But you can also write Powell versus Lee. Yes, Powell versus Lee याद है कि नहीं? Bolton versus Jones, Powell versus Lee. Do you remember that case law? वो headmaster था, उसको हमने job दिया था, but Lee did not have the authority, वो accept कर लेता है. Acceptance is not valid. Please highlight that case law, Powell versus Lee, क्योंकि it must be communicated. वो communication में भी आ सकता है, यहाँ पर भी आ सकता है. वो यहां पर भी आ सकता है, पावल वर्सेस ली इधर भी आ सकता है, क्योंकि it must be communicated only by the person to whom the offer is made. It can be accepted only by the person who has made the offer. Okay, acceptance to whom? To the offerer. By whom? By the offeree. Yes, by the offeree. Silence does not amount to acceptance. Yes, वो communication का है हर्षवर्धन, but you can write it over here also. Acceptance must be given only by the person to whom the offer is made. It must be given and it must be communicated. It must be communicated only by the person to whom the offer is made. दोनों में आ सकता है, दोनों में. मॉड्यूल में they have written in communication, but it can be asked in both. Powell versus Lee में ये था that Mr. Powell applied for the post of a headmaster. So the school authorities decided to appoint him as the headmaster. Mr. Lee without any authority communicated कि अरे सब लोग सोच रहे तेरे को ही अपॉइंट करेंगे, but he did not have the authority to accept. The school authorities appointed someone else. Then in that case Mr. Powell filed a case against the authorities. बोलता है कि तुमने तो मुझे अपॉइंट किया था, फिर किसी और को कैसे कर दिया? Because of you I rejected some other appointment. So can he take action against the authorities? No. Mr. Lee did not have the authority to accept. Offer was not made to him. So in that case, Mr. Powell could not take any action against him. ठीक है? Silence does not amount to acceptance. Acceptance must be communicated and acceptance must be given in the mode specified. Time, acceptance must be given within the time specified. अच्छा मेरे को एक बात बताओ, what if time is not specified? तो क्या करेंगे? What if the time is not specified? Then acceptance must be given within a reasonable time. Yes, absolutely right. It must be given within a reasonable time. Correct. ब्रॉगडन वर्सेस मेट्रोपॉलिटन भी चलेगा स्टेफी वहां पर कम्युनिकेशन में. रीजनेबल टाइम में देना चाहिए. एक्सेप्टेंस मस्ट बी गिवन बिफोर द ऑफर लैप्सेस. बिफोर द ऑफर लैप्सेस. Yes, it must be given before the offer lapses. Expressed acceptance हो सकता है, implied भी हो सकता है. Can you give me an example of implied acceptance? Can you give me an example of implied acceptance? Case-based questions are asked on this. Highlight case-based questions. Can you give me an example of implied acceptance? Yes, Kinnary, correct answer. सही जा रहे हो. No, LR, riding a bus is implied offer. We board, okay? We board the bus. That is implied acceptance. Traveling in a bus. Fall of hammer. That is implied acceptance. Implied acceptance. Communication. No need to refer this theory. Just go through the example that I am giving you. Okay. X. Now see how I am writing the example, students. This is going to help you a lot in the exam. X offered to sell his flat to Y. He wrote a letter and he posted the letter on 5th April. It reached Y on 7th April. Y posted the letter of acceptance on 8th April and it reached X on 10th April. Did you understand how I have written the dates? Okay. X offered and he wrote a letter on 5th April. It reached Y on 7th April. Y gave his acceptance on 8th. He posted his acceptance on 8th and it reached X on 10th April. Can you tell me when is the offer communicated? When is the offer communicated? Can you tell me the dates? Yes, 7th April. See, all dates go cross. Offer is communicated by 7th April. 7th April. 7th April. 7th, when it comes to the knowledge, of Y. अच्छा, Y ने अपना acceptance post कर दिया on 8th, and can you tell me when is the acceptance complete as against X? When is it complete as against X? For X, acceptance is complete as on 8th. And for Y, yes guys, correct. And for Y, it is complete on 10th. For X, it is complete, offer is accepted on 8th. X के लिए contract बना on 8th. And for Y, the acceptance is complete on 10th. For Y, it is complete on 10th. For X, offer is accepted on 8th, and for Y on 10th. Achha, now if I ask about revocation, X wants to revoke his offer. तो वो कौन से डेट से पहले रिवोकेशन कर सकता है? X can revoke his offer before. बोलो. Yes, Harsh, I will come to your doubt. हर्षवर्धन, मैं आपका डाउट सॉल्व करूंगी. Just wait. So revocation can be before 8th, that is before he is bound by the offer, and acceptance can be revoked before 10th. Acceptance can be revoked before 10th. Harshvardhan, what if the letter and revocation, they reach at the same time? Then whichever letter is opened first. If the revocation is opened first, then offer is revoked. If the letter of offer is opened first, then it's a valid offer. So it depends on whichever letter is opened first. Okay. Now students, if you write it in this format, you will never go wrong. कोई भी question आ जाए, you will never go wrong. Okay guys, did you understand? So with that, we have whichever is opened first, whichever is viewed first. Hi Krishna Reddy, how are you? Welcome. All right. Let us now begin with consideration. We have finished unit 1. I invested a lot of time because many case-based questions are asked from that part. Okay, yes. Next, let us discuss consideration. Consideration is the most important element of a valid contract. No consideration, no contract. An agreement without consideration is void. An agreement without consideration is void. Consideration means loss to one party, gain or benefit to the other party. Now let's say, for example, that X offered to sell goods to Y for rupees 10 lakhs. Consideration for X is rupees 10 lakhs. This consideration is gain for X, but this 10 lakh is loss for Y. Y बोलता है I will buy goods for 10 lakhs. So this is loss. Now what is the consideration for Y? Consideration for Y is goods. This consideration is gain for Y, but it is loss for X. It is loss for X. Very good, Harshvardhan. Correct. Quid pro quo. Arya, yes, it means something in return. Something in return. It means something in return. What are the essential elements of consideration? Consideration must move. Yes, consideration must move at the desire of the promisor, but it may be given, it may be supplied either by the promisee or any other person. Now over here, I wish to give you an example. Consideration must move at the desire of the promisor. Let's say that I am walking and I saw that you and your friends are studying law and you're struggling. I come to you and I help you. After 2 hours of teaching you the concept, can I say each one of you pay me 1,000 rupees now? You will not give because I have not because you had not asked me to come and teach you, right? मैं तो सामने में तो voluntarily आई. So in case I give some service voluntarily, then I cannot ask for consideration. But if I come at your request, now this time you asked me to come and teach you. If I have come at your, now this time I have come voluntarily. I can't tell you at the end of every session, chalo, everybody pay me 100 rupees. But if you call me and I come because you have called me, then that is valid consideration. So consideration must move at the desire of the promisor. Yes, Jatin, correct case law, Durga Prasad versus Baldev. Durga Prasad versus Baldev. Very good, Harshvardhan. Correct. But it may be given, it may be supplied either by the promisee or any other person. And very important case law, Chinaya versus Ramaya. Chinaya versus Ramaya. Yes? So consideration may move from any other person. Students, I had done booster videos, and I had also done a separate video on stranger to contract and stranger to consideration. So please go and watch that video later. If you want, I will share it in the group. In that, I have explained the entire case law Chinaya versus Ramaya, because it's a very lengthy case law. It has so many concepts. I'm not doing it now, but I will share the video with you. Okay, you can watch that video. I have explained Chinaya versus Ramaya, stranger to contract, stranger to consideration in detail. Everything is explained over there. Yes, Fatima. Fire and neighbor wala example. Yes, correct. Consideration must be of some value. Consideration means something in return. It can be anything of value. It may seem adequate. It may seem inadequate. Inadequacy of consideration will not make the contract void. Harsh, I'll share it now. I'll share it right away. I'll share it in my study group as well as my doubt solving group. Mostly doubt solving group. I'll share it over there. I'll share it in my doubt solving group. I'll do it right away. आपको मिल जाएगा वो video. I don't want to forget. It's an important video, students. I have explained the entire case law over there. And the difference between stranger to contract and stranger to consideration. I am sharing it in my doubt solving group. CA Foundation doubt solving group. I just shared. Okay, done. I have shared it in my doubt solving group. I am also sharing it in my status. If you have saved my number, you will be able to view it in the status also. So it is very convenient nowadays, you know, sharing data. So please save my mobile number. Yes, I'll share my mobile number also with you. Save this mobile number and you can view it in my status. Okay, status में है ये. चलो guys. Now, अच्छा, consideration may be adequate, it may seem inadequate. Inadequacy will not make the contract void. तो ये कब consider करेंगे? When will inadequacy of consideration be considered? Naman, you can join the group. It's an open group. See in the description box मैंने दिया है. Yes, I'll share it in the Telegram group also. Doubt solving का I'll share it. But do join the doubt solving group. बहुत काम में आता है in exam. During exam time, you know, you can share your doubts. You can ask your doubts. So it is considered when the consent is not free. Consent is not free. Okay. Only to show that the consent is not free, that time we will use inadequacy of consideration. Very good, Jatin. अच्छा लिखा है आपने. Consideration must be real and not illusory. Illusory means imaginary नहीं होना चाहिए. Imaginary means it only looks like consideration, but actually it is not consideration. ओके तो आपका जो कंसिडरेशन है वो इमेजिनरी इल्यूजरी नहीं होना चाहिए. It should be real, it should be actual consideration, it should be real consideration. Consideration may be past, it may be present, it may be future consideration. What is the meaning of past consideration? What is the key word in past consideration? The consideration which has moved. When? Yes, correct answer guys. सब बहुत अच्छे से लिख रहे हो. What is the key word in past consideration? Past consideration means consideration which has moved before the formation of the contract. So what is the key word over here? It is before. Consideration has moved before the formation of the contract. Students, please note, please note, please note. It is before, but it is at the request of promisor. This should be there in your answer, okay? Now, let's say, for example, A gave tuitions to B. A gave tuitions to B at B's request. Then later on, B promised to pay 5,000 rupees. Now over here in this 5,000 rupees, there is consideration for A 5,000, but B को तो कुछ भी नहीं मिला. अरे अभी नहीं मिला है, पहले तो मिल गया था ना. और ये पहले कैसे मिला? It is at the request of B. Only when the consideration moves at the request of the promisor, then that past consideration is valid. This is very important. You must remember this for the exam. In England, past consideration is not considered as valid. Yes, English law does not recognize past consideration. Indian law past consideration को मानता है. Correct. What is the key word in present consideration? Present consideration का अगर question आया तो आपके आंसर में क्या होना चाहिए? What is the key word? Simultaneously. Consideration which moves simultaneously. मैंने आपको लेक्चर दिया, आपने मुझे तुरंत पैसे दे दिए. When the consideration moves simultaneously. Yes, when it moves simultaneously, then it is, it's also known as executed contract. Very good, Jatin. Superb, superb. बहुत अच्छा लिखा आपने. This is also executed contract. It can be executed. No, it is considered as executed contract. Executed consideration बोलो. Executed consideration. Yes. Future consideration. Future consideration मतलब क्या? Future consideration means it moves after the formation of the contract. Yes, the key word is simultaneous. Very good, guys. Now, consideration must not be, it moves simultaneously. नहीं प्रथम, in future it is known as executory. Yes, मुझे लगा आपने previous का आंसर दिया. Executory consideration. Okay. So consideration must not be something which the promisor is already bound to do. अच्छा, let's say for example that X ने पुलिस से कहा that I will pay you 5,000 rupees if you find the thief. अरे अगर तुम ये प्रॉमिस नहीं भी करते तो भी पुलिस की ऑब्लिगेशन है टू फाइंड द thief. 5,000 is not going to create any extra loss or any extra benefit. That's not valid consideration. Okay, it's not valid consideration. So you should not. But what if I perform duties which are beyond my obligation? मेरी obligation नहीं थी, फिर भी मैंने extra काम करे, then that is valid consideration. Yes. Consideration must not be illegal, immoral, or opposed to public policy. It should not be illegal. Illegal means it should not be forbidden by law. What is the key word over here? It should not be forbidden. Like say for example, drug dealing. It should not be immoral. What is the meaning of immoral? Yes, Fatima, correct answers. Correct answer. Immoral, the best example that you can take is prostitution. ये institute का favorite है. Prostitution institute का favorite example है. Yes, they are values. Values है society, correct. Opposed to public policy means it is opposed to society, like giving donation for admission, like giving donation to college. जो डिजर्विंग कैंडिडेट है वो रह जाएगा और जो डोनेशन देने को तैयार है उसको जॉब, उसको एडमिशन मिल जाएगी. Such consideration is void. It is illegal. It's illegal. It is opposed to the society. Yes, Pratham, correct. Admission through by giving donations. Now, students, what kind of question will be asked on this? Essential elements. It is important for 7-mark question. Okay. Theory question, 7 marks. A theory question can be asked for 7 marks. Don't give examples if you feel that it is very time consuming. Jatin, in case of prostitution, you have given a house on rent to a prostitute to carry out her trade. So giving the rent to a prostitute so that she can carry out the prostitution activities, the consideration, the rent involved, that is unlawful consideration. It is immoral. It is for immoral activities. आप अपना घर भले ही ले सकते हो लेकिन वो जो रेंट है वो नहीं ले सकते. Yes, a direct question, Fatima, 7-mark direct question will be asked. Okay, then sued by third party. Okay, sued by third party. Can stranger to contract sue? Tell me, can stranger to contract sue? Can stranger to contract sue? Stranger to contract cannot sue. Now let's say for example that there was a contract between A and B. Okay, A और B के बीच में एक contract है. There is a contract between A and B. A fails to supply the goods. Can C file a case? अरे C तेरा क्या लेना देना, तू कौन है? C cannot file a case because C is stranger to contract. And stranger to contract cannot sue. Stranger to contract cannot sue. Stranger to contract can sue but only under exceptional circumstances. Okay. Stranger can sue only under exceptional circumstances. Only under exceptional circumstances. Yes, privity of contract. According to privity of contract, stranger to contract cannot sue. देखो आपको कैसे पता चलेगा कि वो stranger to contract है या consideration है? C has no contract with either A or B. Okay, he has no contract with either A or B. He may be getting benefit, but he has no contract with either A or B. C is a stranger. Now, how will you understand stranger to consideration? Like Chinaya versus Ramaya. A is an old lady. She transferred the property in the name of daughter R. Ramaya. R on the same day executed a deed in writing promising to pay the amount to C. बाद में refuse कर दिया. But over here, C could sue. Okay, C can sue because C is stranger to consideration. Why is C a stranger to consideration? C is stranger to consideration as a result of this deed. Deed है, इसीलिए वो stranger to consideration है. If there is no deed, then C would be stranger to contract. So students, if you have a notebook with you, please write, okay, please write if there is a deed, okay, if there is a contract, then you are stranger to consideration. If there is no deed, if there is no contract, okay, there is no deed, there is no contract, then that person is stranger to contract and stranger to contract cannot sue. This is very important. Many students get confused over here. Let me read your comments now. Stranger to contract may enforce a claim only under exceptional circumstances. Since contract is a private relation between parties. Okay, yes, Naman. Harshvardhan, notes, you can download it from the link given in the description box of this video. So I have given you yes. Naman, there is a separate video which I have shared. I'll share it over here also if you want. I'll share it over here. Please go and watch that video because it is not possible for me to explain everything in detail, guys. I'll just share that video with you. It is a video on stranger to contract and stranger to consideration. I'll just share it over here only. You can save that video. You can download that video. It's, yes, how to differentiate between stranger to contract and stranger to consideration.
How can we launch from it?
Okay, I'm sharing it over here. So please go and watch that video. All your doubts will be clear. Okay. Now, there are certain exceptions where stranger to contract can sue. Oh, you didn't understand that. हाँ, last में ना. Now, अब यहाँ पर देखो नमन. चिन्हया versus रमया में चिन्हया is stranger to consideration. कैसे? Because C received the benefit as a result of the deed. R ने खुद ही promise करके deed बना के लिख के दिया था ना, I will pay. Deed है, इसीलिए वो stranger to consideration है. और अगर deed नहीं होता तो C would have been stranger to contract and stranger to contract cannot sue. वो केस में C would have lost. C हार जाता. Okay? Now, in case of a trust, stranger to contract can sue because stranger is beneficiary. And beneficiary can sue. Acha, in case of family settlement, let's see for example HUF. HUF में we have kept some money aside for the marriage of a female, or some money has been kept for elders, or some money has been kept for minors education. भले ही वो contract का part है ही नहीं, even then they can file a case because they are all, sorry, मैंने next के लिए example दे दिया, ये इधर का है, sorry. In case of family settlement, let's say कि A and B, they are two brothers, ठीक है, ये दोनों भाई हैं. They have partitioned. Now बंटवारा हो गया है इनमें. Naman, I'm telling you, it is not possible because it's a very lengthy concept. Naman, don't worry. Just go and watch that video of mine. आपका पूरा concept clear हो जाएगा. Okay? It's not possible to explain stranger to contract and consideration in short span of time. So go and watch that video. नहीं समझ में आता है, so you can connect with me on WhatsApp. So I will discuss it over there. Okay? So certain marriage contracts, वो बाद में करेंगे. A and B, they are two brothers. ठीक है? So उनका business partition कर रहे हैं. At the time of partition, they have promised to keep some money aside for the maintenance of their mother. After partition, they fail to contribute. Mother, even though she is a stranger to contract, but even then she can sue. It's an exception. She is the beneficiary. Okay, she is the beneficiary and beneficiary can sue. In case of certain marriage contracts or in case of, let's say, HUF, if some money is kept aside for the marriage of a female, for education, or for elder people, even though they are not a party to the contract, they can sue. In case of assignment of contract, write down the meaning of assignment. Assignment means to transfer. If the benefit is assigned, then assignee can sue. Okay, assignee can sue. Estoppel by acknowledgement. अभी इसका क्या मीनिंग होता है? L has to pay money to N. ठीक है, L has to pay money to N. लेकिन वो M को बोलता है, देख मैं तो डायरेक्टली नहीं जा सकता, I can't go directly. Will you pay these 2000 rupees to N on my behalf? M agrees. M also calls up and he gives acknowledgement. Arey N, listen, I'm holding the money for you. Let me know when you come home. I will bring the money. हम जिसे acknowledgement देते हैं हम उसके agent बन जाते हैं. So in this case he is agent of N. And what if M fails? Then N can sue M because we can file case against our agent. Yes, Naman, of course, unmarried and we have kept money for her marriage. So she's unmarried, so she can sue. Now in this case, M is considered as agent of N because you give acknowledgement. हम जिसे acknowledgement देते हैं हम उसके agent बन जाते हैं. So N can sue M if M fails to pay. Covenant running with land. Can somebody tell me what is the meaning of the word covenant? What is meaning of the word covenant? What is meaning of the word covenant? Yes, it is conditions attached to the use of land. How are we supposed to use the land? Only for agriculture. That is a condition which is attached to the land. Who will tell me? It is binding on. Yes, it is binding on only the parties to the contract, or it is binding to current as well as subsequent owners. Yes, these are restrictions. Restrictions attached to the use of land. They are conditions attached to the use of land. It is binding on the current as well as future owners. Okay, it is valid on current as well as future owners. Very good. So even though I have not created the covenant, I am still bound if I purchase the land, because land comes with the conditions. It comes with the burden of that conditions. Yes. Hi Adesh, welcome. Hello Adesh, welcome. Contracts with agent. Agent has entered into a contract with third party, but the principal, being a stranger, can sue the third party because ultimately contract तो उसी के नाम पे हुआ है. I am from Mumbai, Naman. From Mumbai. Okay. Guys, in case you have joined late, I have mentioned earlier also, you can download this workbook. Link is given in the description box. After the session is over, I will share the annotated notes in my WhatsApp group. So please join the WhatsApp group. And also visit my website theorymasterslearning.com for the CA Law Compiler. 100% paper will be from that book only. Okay. I'll just share the link of the compiler again for students who have joined late and they have missed the book. I'll share link of the compiler. Okay. Yes. Last part for the day. हमको पता है no consideration, no contract. But there are certain contracts which are valid even without consideration. Adesh, you can download this soft copy. You can take a printout. For the other books, the soft copy is available. Okay, the soft copy is available for compiler. So you can order the soft copy. Harsh, you can try it again. हो जाएगी download. Adesh, you can purchase the soft copy of the compiler and you can view it in Nepal. Okay, chalo. Last part, guys. Tomorrow we will complete the contract act because the other units are very small. इसमें ज़्यादा time लगता है, unit 1 and 2. Okay, agreements made on account of natural love and affection. Yes, Please highlight this as super duper important for exam along with section number, section 25. Super duper important for exam. क्यों? क्योंकि इस पे theory questions आते हैं. Yes, theory questions are asked. And natural love and affection पे case based questions आते हैं. Yes, who will tell me the 4 conditions required to be satisfied for the contract to be valid under natural love and affection? What are the 4 conditions to be satisfied for the contract to be valid? Natural love and affection. Okay, so the contract must be based on natural love and affection. लेकिन उसके पहले भी और क्या requirements? I'll write it in sequence only. The agreement must be in writing. Yes, very good. It must be signed. It must be registered. Writing है तो sign तो होगा ना. It must be registered. It must be based on natural love and affection between people who are in, between persons who are in near relation. Yes, very good. All 4 conditions have to be satisfied cumulatively. All 4 conditions have to be satisfied, only then it will be a valid contract. All 4 conditions have to be satisfied. Then, who will tell me what are the conditions for past voluntary services? Contract will be valid for past voluntary services. For past voluntary services, when will the contract be valid? Services should have been rendered voluntarily. Services should have been rendered for the promisor. He must have enjoyed the benefits. And he must have intention to pay, compensate. Near relation होना चाहिए. Near relation means relation of blood, but हर्षवर्धन it can also contain relation of husband wife. हाँ, तो उसमें blood relation नहीं है. Blood and husband wife दोनों included. Yes, Ramu. So it should be voluntarily. It should be done for the promisor. He must have enjoyed the benefits, and you must have intention to compensate the promisor, the promisee. Then these contracts are valid even without consideration. Yes, correct, Kinnari. Arfan, correct answer. Very good. अच्छा, टाइम बार डेट मतलब 3 साल खत्म हो गए, 3 years are over, so it is beyond 3 years. Okay, it's legally not enforceable, legally not recoverable, but now A has promised to pay B a time barred debt. What are the conditions to be valid for a time barred debt? What are the conditions to be valid? Guys, if you're enjoying the lecture, please give me a thumbs up. Yes, please give me a thumbs up. Please like the video. If you're enjoying it, please like the video. It means a lot to the the viewers, and it motivates me also. If you have liked today's session before leaving, please like this video. Okay, yes, I got my answer. It should be in writing. It should be a promise to pay a time barred debt. And it must be signed either by the person or his agent. It must be signed by the person or his agent. Thank you so much, everyone. Thank you. Please like the video. Please like the video. Thank you so much, guys. Your comments and your support means a lot. Yes, thank you so much, guys. Okay, we are almost coming to an end. कल कॉन्ट्रैक्ट एक्ट कंप्लीट करना है हमें. Okay, in case of contract of agency, no consideration, no contract is required to appoint an agent. एजेंट को अपॉइंट करने के लिए कॉन्ट्रैक्ट देने की, कॉन्ट्रैक्ट और कंसिडरेशन की भी जरूरत नहीं है. So no consideration is required to appoint agency. अच्छा, very important, completed gift. Completed means I have given the gift. Can I ask for return gift? We ask, that is another case. But in case of gifts which are completed, it's a valid contract. Okay, it's a valid contract. But what if I have only made a promise? Only promise. Yes, Jatin, correct section. For completed gifts, I do not require consideration. But what if I have only promised? मैंने सिर्फ promise किया है कि I will give you a gift. Will that be a valid contract? No, this is not a valid contract. Same logic applies to charity also. Charity which is completed. I gave a gift. So this is a valid contract. But I have only promised. This is not a valid contract. अच्छा सुनो, मेरे promise के basis पे सामने वाली पार्टी ने expense कर दिया. X promised to donate 5,000 rupees to Y and Y has incurred expenses of rupees 3,000. Then tell me, is Y liable for some amount? Is Y liable? Yes, Y is liable to pay at least 3,000. He is not liable for the entire 5,000, but he is liable to pay at least 3,000. Correct answer. Very good. Bailment. Yes, last point. Bailment means to deliver. Now, A bailed goods to B for safekeeping, transportation. Okay, let's say safekeeping. They are friends. No consideration is required. Okay, no consideration. Yes, correct. Kedarnath versus Gauri Muhammad. Ankita, correct. Kedarnath versus Gauri Muhammad. It's the exact case law. Correct. In case of bailment, A bailed goods to B for safekeeping. So in this case, they are friends. B is saying, no, I don't want any consideration. Even then, the contract is valid. So bailment contract is valid even without consideration. ये कुछ consideration नहीं ले रहा है. Still, it is a valid contract. Okay, so consideration is not required in case of bailment. He is still bound to keep my goods safe even though I have not paid anything to him. So students, with this we complete the unit of consideration. Tomorrow I am going to finish the contract act because contract act takes 2 days. It's not possible to complete everything in one day. Mostly the time is involved in the first 2 units. 3, 4, 5 and 6 is very small. So it will not take time. Alright. So tomorrow we will complete the contract act and then we are left with only sale of goods, partnership and LLP. So day after tomorrow I will cover sale of goods act and then we will finish partnership and LLP. Sunday will be the last session. Next week we will go for BCR revision, format revision. Okay. So for today's session I am ending the session here. I really enjoyed myself and today also spirit बहुत ही high था आप लोगों का. You all participated a lot. I'm so happy and so proud of you guys. Before leaving, I would just like to share something with you. Students, you guys are very lucky क्योंकि आप लोगों को yes, thank you so much guys. And जाते जाते just a few sentences for you students. Just I want to share my feelings. You guys are extremely lucky students कि आपको social media के वजह से कितना support मिलता है. You know, there are so many people who are connected with you. Okay. Yes, Ankita, we are going to finish that also. But you guys are very lucky because हमारे time पे we had to really struggle to understand everything. Now you have so much material available. Please make use of that. We all have very high expectations from you guys. You all are capable. You all can achieve great heights. Only thing is now you need to concentrate for the remaining 20 days. देखो स्टूडेंट्स, 20 डेज में भी आप सीए कर सकते हो, सारी पढ़ाई कर सकते हो. 8-10 घंटे डाल दो. Just put in all your energies in this course. And I always tell my students this: don't do it for yourself, do it for your parents. When my dad or my mom, they tell someone that my daughter is a chartered accountant, उनका expression जो सामने वाला ऐसा रहता है, chartered accountant. My mom used to always initially come and tell me कि अरे किसी को भी बोलो my daughter is a CA, तो they are like, hey, CA अच्छा है, अच्छा है. CA is one course which has not lost its sheen. उसका जो शाइन है, वो डिमांड है, वो अभी भी वैसा ही है. मतलब कितने साल हो गए, इतना पुराना कोर्स है, लेकिन आज भी किसी को बोलो आई एम अ चार्टर्ड अकाउंटेंट, वो यही एक्सप्रेशन, यू आर अ चार्टर्ड अकाउंटेंट. अरे इतना अच्छा लगता है ना वो सुन के. व्हेन जस्ट 2 letters एडेड बिफोर योर नेम. मेहनत बहुत करनी पड़ती है उसके लिए यार, बहुत. मतलब आई कांट इवन इमेजिन कि आजकल क्या स्टूडेंट्स गो थ्रू कर रहे होंगे, बिकॉज हमने भी वही किया है. बट अभी तो क्या एक्सपेक्टेशन और भी बढ़ गई है ना, बिकॉज द लेवल ऑफ एग्जामिनेशन हैज इंक्रीज, डिफिकल्टी लेवल हैज इंक्रीज. लेकिन सीए का वैल्यू आज भी उतना ही है. आई यूज टू गो टू द पब्लिक लाइब्रेरी. हमारे कॉलेज की लाइब्रेरी थी, उसके बाद व्हेन कॉलेज गॉट ओवर आई यूज टू गो टू द लाइब्रेरी. वहां पर पढ़ाई की मैंने. एंड फोकस्ड रहने के लिए यू डिसाइड द प्लेस कि आपको कहां पर रहना है. मुझे माई फोकस वॉज इन द लाइब्रेरी, सो आई यूज टू गो देयर एंड स्टडी. आपका फोकस किधर है, आप वहां पे जाके पढ़ो. एंड आई यूज टू स्टडी फेसिंग द वॉल. मतलब मेरी जो लाइब्रेरी थी, आई रिमेंबर आई यूज टू सिट इन अ प्लेस एंड फेस द वॉल. बिकॉज बाकी लोगों को देखे ना बहुत टेंशन आती है, और वॉल को देखते हैं ना तो ऐसे लगता है यार बस मैं और वो है और मेरी पढ़ाई है और कुछ भी नहीं है. सो सिट इन अ प्लेस जहां पर आपको कोई डिस्ट्रैक्शन नहीं है. You and your studies and your books, stay focused students. लास्ट के 20 दिन है, अभी भी पॉसिबल है. Put 8 to 10 hours कर सकते हो आप. और इतने अच्छे से आंसर दिया यार आप लोग ने. मेरी तो बहुत एक्सपेक्टेशन है फ्रॉम ईच वन ऑफ यू, कर लोगे. ओके स्टूडेंट्स, सो ऑन दिस नोट आई वुड लाइक टू एंड द सेशन हियर. इफ यू फील डीमोटिवेटेड, कभी भी लो लगता है, मैसेज करो, वी आर देयर टू हेल्प यू. डोंट वरी अबाउट दैट. एंड यस, I will be completing Contract Act tomorrow. Day after tomorrow, Sale of Goods Act. Last day, Partnership and LLP. Okay. Thank you so much, Nikhil. Thank you. So, in case, guys, you want any assistance, I'm sharing my mobile number with you. You can contact me on this number and I would be very happy to guide you. All right, guys. चलो यार, बहुत भूख लगी है, अभी काफी टाइम से बैठे हैं यहाँ पे. आप लोगों ने तो आपका डिनर भी कर लिया होगा लगता है खाते खाते हैं. निखिल, अभी बात नहीं करते हैं. यू मैसेज मी ऑन व्हाट्सएप, वील डिस्कस. देखते हैं क्या कर सकते हैं. ओके आर्या, डोंट वरी अबाउट एग्जाम्स डियर. जस्ट थिंक अबाउट सीए इंटर के बारे में सोचो. थिंक अबाउट सीए इंटर कि आप क्लास में कैसे जाओगे, आप लेक्चर्स अटेंड कर रहे हो, आप आर्टिकलशिप जा रहे हो आफ्टर योर इंटर. इमेजिन कि आप ऑलरेडी इंटर में पहुंच गए हो. स्टे पॉजिटिव एंड दिस विल बी कन्वर्टेड टू अ रियलिटी. डोंट वरी. डर तो लगेगा, अरे डर अच्छा है, फियर इज गुड. मैं तो बोलती हूं जितना डरोगे उतना आप पास होगे. डरो, बिंदास डरो. एंड फियर इज गुड. फियर को कभी भी नेगेटिवली मत लो. यू विल परफॉर्म योर बेस्ट व्हेन यू आर स्कैर्ड. आई एम टेलिंग यू. तो डरना बहुत अच्छा है, डर अच्छा है. ठीक है, चलो स्टूडेंट्स, आई एम एंडिंग यार. मेरे को बहुत भूख लगी है, अभी बहुत टाइम से बोल रहे हैं यार, अभी तो एनर्जी भी खत्म हो गई है. चलो, गुड नाइट गाइज. आई एम एंडिंग द स्ट्रीम हियर. I'll see you tomorrow at 7 o'clock. Before leaving, like the video, give a thumbs up and comment में जरूर लिखना कि आपको लेक्चर कैसा लगा. Yes, bye guys. Yes, Nikhil, that is the number on which I can be reached. आप ये नंबर पे कांटेक्ट करो, not today, tomorrow, okay? अभी नहीं, कल कांटेक्ट करना, बात करेंगे एंड आई विल गिव यू सम सोल्यूशन. कुछ एक फास्ट ट्रैक करते हैं आपके लिए कि इतने दिन में कैसे कंप्लीट कर लोगे. ठीक है, चलो बाय बाय. बाय जतिन, बाय एवरीवन, बाय किन्नरी, गुड नाइट.